Hi everyone, welcome to the community classroom. This is Dr. Tracey McCarthy, psychologist, attorney, and educator. This is a continuing discussion / lecture related to the first video addressing the ongoing discussion that is occurring between a variety of individuals. Their names are Seren, and I pronounced the name wrong in the first video. Her name is Tamar Luvvie, Amanda Seales, and Yvette Carnell, and ADOS. And ADOS is the article writer of the article related to my great-grandfather, the Nigerian slave trader. And so we are continuing on, and we're going to now discuss an issue known as standing. And standing is a legal issue that has been brought up in a number of these discussions, but the word standing has not been used. And so I'm going to now give you the legal framework for the construct that has been discussed. And so what people are talking about, particularly Seren and Yvette Carnell, are the issues related to this doctrine of legal standing. So let's go there. And one of the reasons we're addressing this is because one of their assertions happens to be related to the distinctions between race and ethnicity and the issue of standing. And what I'm hearing asserted is that there is standing related to ethnicity that does not necessarily include standing related to race. Okay, so what is standing? Standing is basically a legal doctrine. It's a constitutional doctrine. It comes out of Article 3 of the Constitution, and it's related to what's known as cases and controversies. And basically, the doctrine indicates that the federal courts, not the state courts, but the federal courts have the power to hear cases that arise under federal law. And so that means things that would be related to issues of federal jurisdiction. And so this would be, federal law issues and controversies. And it only involves certain types of parties. And so we're going to talk about these certain types of parties because everyone does not have what is known as legal standing. And so we're going to address that. Now, the idea of legal standing, it applies in a legal context, but you could also extrapolate the idea of standing to policy determinations, to legislative actions, and those sorts of things. And so standing is just basically the ability of a party to show to the court that they have a significant and sufficient connection to whatever harm it is that they are alleging from a law that might have been passed or an action of a party. They're showing that they have a significant, sufficient connection to the action or the harm that's being alleged. And it's standing is very important because it signifies a legally protected or protectable stake or an interest that a person, a party, has in a particular dispute that allows them to bring that case and controversy before a court to obtain what is known as judicial relief, some sort of relief, some sort of repair, some sort of restitution. And so what the courts are looking for when an individual is asserting standing or the standing to sue, standing to bring suit, they're looking to see if the person who is making this assertion actually has a legal interest that has been invaded, that has been violated in some sort of way by whoever the defendant is in the case. And so one of the important things to note about standing is that simply being a member of the public is not going to give someone standing in a case. People can't just assert a standing simply because they belong to the public. A person actually has to have what's called a personal stake in the controversy. And so they actually have to have a personal investment in some sort of way in the controversy. Back in 1984, there was a Supreme Court decision that looked at this issue of standing, and the court established that a significant injury for one of the claims, it had to find that the causation of the injury had to be directly related. You can't really have a weak or an attenuated connection to the harm. There needs to be a direct impact, or there needs to be a sanctioned indirect impact. And so it needs to be fairly traceable. You need to be able to fairly trace that harm and the impact. And there are three requirements for standing, and in law we call it, a three-prong test, if you will. And so there's a three-prong test for standing. And the first prong is you have to show that there was an injury in fact. And so basically what that means is that the individual who is asserting this harm, the plaintiff, if you will, they must have suffered or imminently will suffer some sort of injury or an invasion of a legally protected interest or right. It needs to be concrete and particularized, and there needs to be an actual or imminent harm. It can't be hypothetical, can't be something in the abstract. Law is very tangible. It's not abstract. It's not things that sort of happen in the air. And so, and the injury, it doesn't have to be an economic injury. I know that sometimes people tend to think of the law in terms of economics, but there are all sorts of injuries and what we call redress actions that can take place that may have absolutely nothing to do with economics, with money. But often money damages and things like that, there's often an economic interest in many cases and controversies. And so, but the injury doesn't have to be economic. It can be economic, it can be non-economic, it can be a combination of those things. And let me give you a little caveat about the injury in fact, to kind of give you an idea of the distinction between just someone in the general public versus someone who has actually been injured according to the law. Let's take emotional distress, for instance. A parent could possibly sue for emotional distress for an injury that actually occurred to the child, and the parent standing right there when this harm occurs in relation to the child. There could be a stranger standing right there also when this harm occurs in relation to the child, but that stranger would not necessarily have or generally have what is known as standing in that particular case, and so they wouldn't be able to assert an action for harm based upon harm that happened to someone else's child. Okay. The other prong is what's known as causation. And causation basically is looking to see if there is a causal connection between the harm or the injury and the conduct that the injured party is complaining of. And so you want to see that the harm that the person is suffering in the moment, that it is fairly traceable to the actions of another entity. And so that traceability needs to be there. And also sometimes there can be an intervening circumstance that will sort of cut that traceability. And so what the courts are looking for is that idea of causation. It's sort of like if there's a car accident, You're looking to see if there's negligence. You're looking to see if the person had a duty, and then they breached that duty, and that breach of that duty is what caused the harm to the plaintiff or the person who is complaining. The other issue, the third part of that three-prong test, is redressability. And what redressability is looking at is, it's not looking at speculation. It's looking to see if the court makes a favorable determination, is it possible that that favorable determination can actually redress the injury that is complained of by the plaintiff? Now, redressability could relate to damages, which I mentioned before. It could also relate to what's known as equitable relief, or something in equity, which could be injunctive relief, or something else that would repair the person or put them in the place they would have been in had the original injury not occurred. Okay, so that's considered making someone whole. Now, one of the other things that the courts tend to look at is this idea of whether or not the harm is related to being subjected to a law or some sort of governmental legal action, such as a statute. If a statute was the basis for the harm, or if a judicial action, such as the Dred Scott decision, was that the basis for the harm? And so there are three other things that the courts look at. They look at whether or not the party is directly subjected to an adverse action, or are they directly impacted by this statute or the action that's in question. They look to see if the harm suffered might even continue unless relief is actually granted in some form or fashion. And this is referred to as the something to lose doctrine. So in other words, if the court doesn't intervene and redress does not occur, does the person have something to lose in the particular case? And the other thing that the court looks at is whether a party was not directly harmed by the condition, by the harm, the original harm, but if they are looking to see if there is a reasonable relation to the original harm and the harm that the person who is asserting the current harm, if there's a reasonable relationship, a reasonable connection between those two things. And so it could be something as simple as a party in a probate action. Something happened in the probate action and someone didn't get their proper inheritance. And so it may have been that a great-grandfather was not allowed to get a proper inheritance, and so therefore you have descendants of that grandfather or that grandmother who would then be asserting that they have been harmed down the line because of the harm that was originally done to the grandfather in a probate action, for instance. And then in some instances, standing may be granted, it may be automatic simply by an act of law. And so those are the three other ways that the courts think about this issue of standing. Now, sometimes individuals will argue that a person does not have standing if they are a third party, and that's that sort of prohibition related to third party standing. And so a person can only assert a person's own rights. They can't basically raise the claims of a third party who is not before the court. An exception to this is, though, when there are what are known as interchangeable economic interests. And this kind of goes back to the example with probate and the grandfather and the grandchildren. Okay, so if there are interchangeable economic interests with the injured party, then a person who did not receive the protection before the third party descendant, if you will, in that probate type of action, that third party could conceivably assert a right based upon what happened originally to the grandfather. And basically, they would be asserting that they technically have an inheritance right based upon the grandfather's original rights. And so what the courts are trying to do is basically prohibit what's known as a generalized grievance. And so you don't want, the entire public asserting a harm, when they can't be differentiated. And so what the courts are looking for is that the plaintiff actually has an injury that's not widely shared with, countless people. In other words, the general public. And so, for instance, a group that is easily differentiated would be Native American, First Nation, Indigenous, Aboriginal tribes. There may be harms that the general public might experience, but there are harms that they suffer specifically. And so they would be able to assert certain actions that the general public would not be able to assert. For instance, issues with the pipeline, those individuals in various tribes that might be impacted could assert that. And also people along a pipeline could also assert it, but it wouldn't be something that the general public would assert if they aren't directly or indirectly impacted by a pipeline of sorts. And finally, and this really can apply to policy issues too, is this idea of the zone of injury and the zone of interest. And basically that's looking to see if the injury that an entity is complaining about is the type of injury that Congress, for instance, would have expected to redress or address. And so there's also this interest of this idea of the zone of interest. And that's basically where they're looking to see if the party is arguably within the zone of interest that's protected by a particular statute or a constitutional provision. Now, there are some cases that address standing that are really good to look at. So if someone's really interested in getting a better idea of this issue of standing, there are some Supreme Court cases that some individuals might look at if they are interested in this issue. And let me just give you the names of those cases just in case anyone is interested in looking them up. The first and most important one often is seen as Dred Scott, and it's Dred Scott versus Sanford, and that was from 1857. Another case would be Fairchild versus Hughes from 1922, and then Baker versus Carr in 1962. And so finally, and let me give you an overarching way of looking at standing. Standing is about, is the person standing in the shoes of one who has a right to be asserted? Are they standing in the shoes of someone who has actually been harmed or who actually has the potential to be harmed? And so that's what standing is really about. I'm hoping this discussion made the issue of standing a bit more clear for individuals who were confused about standing, if anyone was confused. And I'm also hoping that it gives people a framework for understanding standing and also language to use in discussing this issue of standing, because I think sometimes a lot of confusion occurs because of language. And when people have the language to discuss a particular issue, it makes it easier for everyone across the board. And so if there's a standard language for understanding something, then it makes the discussion flow a little easier. And so I hope that was helpful. If anyone has any comments or reflections, you can put them in the comments section. Remember, knowledge is power. Take care and see you soon.